Good evening, everyone. I'm Rashmi from greytHR and today's moderator of this session. I would like to welcome all of you today to our 9th Thought Leadership webinar, greytHR Meets. And as you may know, the topic for our today's session is 2023 UAE Employment Law changes and the implications of it for employers and employees. So we are going to discuss about this in detail in just a few more minutes. But before that, let me just give you a brief introduction on what are we going to discuss today. So as we all know, there have been several updates in the employment sector in the United Arab Emirates, which will have implications for employers and employees. The updates mainly affect Emiratization targets, employment contracts, and working and overtime leave entitlements, including the introduction of bereavement leave, study leave, and sabbatical or national reserve leave. So in the next 1 hour, we are going to discuss about all of this in detail with our esteemed speaker, Mr. Ahmad Al Khalil, and the partner and head of corporate and advisory department, Hamdan Al Shamsi, lawyers and legal consultants, and understand the 2023 UAE employment law changes and its implications for employees and employers. Well, before we dive into the topic, let me tell you a little more about Mr. Ahmad here. So Mr. Ahmad has a rich experience of over 15 years, and he has studied at the University of Bristol in the United Kingdom, LLB, and has a master's degree in business administration from New York Institute of Technology in Jordan. At Hamdan Al Shamsi, lawyers and legal consultants, he heads up the corporate department, who is responsible for the advisory and transactional side of the firm. So, Mr. Ahmad, we are honored to have you here in the session. Once again, welcome to the session.
Hi, thank you so much for that. Thank you, Ms. Rashmi.
We have our partner here in our today's session, Mr. Rashid Nurangan. So to tell you more about Mr. Rashid, he's the managing director at Webcom with an ability to transform ideas into long-term sustainable business operations. He set up his own business for IT products in 2011. He has a rich experience of 13 years having successfully driven software implementations for many corporate groups. So, Mr. Rashid, we are delighted to have you here in the session. Welcome to this session once again.
Thank you, Rashmi. Thank you.
So, Mr. Rashid, I would hand over to session to you now. So, if you'd like to share the presentation, I'd love to do that.
Sure. Hi, good evening all. First of all, I would like to appreciate greytHR for giving us a chance to conduct this session related to today's topic. Webcom, actually, we have been conducting a series of sessions for our customer to increase their product knowledge and update on the compliances. We have been dealing IT product in this market quite a long time, more than 13 years. And we are covering almost all Emirates in UAE. Our company is located in Sharjah, which is handling all the IT products, including ERP software, retail solution, HRMS solutions, and cloud-based systems. And we have been catering our customer last 13 years. We already covered more than 5,000 customers in this region. And we are primary partner for Tally software last 10 years. Our company has been recognized as the best Tally partner for this region several times. In 2022, we have selected like elite business partner for this region. These are the few of the recognition what we received from Tally. And our specialty is like we have a complete team for sales and implementation. We have a developers here who can develop the product on top of the existing product. We can do integration with other products. We have a dedicated support center here to service our customer from 9 a.m. to 6 p.m. Throughout the journey, we have been considering our customer in terms of support and implementation and sales. Now, we are happy to take this greytHR, which is a complete HRMS solution for your organization. We are all know a better culture inside the company is very important for us. So HRMS solution is, greytHR is one of the best product which you can help you, which will help you to manage your HR and payroll. It is going to manage, it is a complete automated product. It is a cloud-based system. It is having almost all modules, including employee management. It is having like communication with your employees. There is leave management system. It is having like a document management, and the product is completely almost innovated system based on the market requirement. It is always up to date in terms of compliances. So this session is not for product. So we are happy to receive your call and come to your place and demonstrate the product for your company. I would like to request you all, please ask your question during QA session and get answer for your queries. And we are happy to talk about our customer. This is the few of our customer, which we have been handling quite a long time. Please reach out to us if you need to know more about the product. We are happy to come to you and get and help you to help you related to the product. Thank you so much.
Thank you, Mr. Rashid, for the wonderful presentation. Dear attendees, now we are moving on to our today's discussion with Mr. Ahmad. And as I already mentioned, our today's topic for the discussion is 2023 UAE Employment Law changes, the implications for employers and employees. Mr. Ahmad, before we dive into the details, could you please provide our audience with a brief overview of the key changes that have taken place?
All right, thank you, Ms. Rashmi. So, hi everyone, good afternoon, good evening, and good morning, depending on where you're checked in from. We appreciate you coming online and just coming to see us. Hopefully we'll get some good feedback, and if there are any questions that are still pending after the conversation, please do feel free to reach out to Ms. Rashmi and the people who are hosting this webinar so that we can assist any way we can. In terms of the new law, so the new law came into play last year and had some significant changes to it, chief among which was the fact that you no longer have the concept of an unlimited term contract and a limited term contract. This was one of the fundamental differences between the old law and the new law. And it plays a significant part because back in the day, people would understand that if I have an unlimited term contract, I'm there for an indefinite period. Whereas when you see that it's actually defined as 1 year, 2 years, some of the clients have come to us as employees, for example, and said, well, what does this mean for me in terms of job security? So this became a bit of although not a legal discussion, it became more of a tenure problem. So people who have been with the company for 15 years, all of a sudden had, to contend with 1 year on their contract, renewable the year after. So certain things have been clarified by the new law that were not clarified back in the old law. Some things have become a little more not muddled up, but we still need to see how they will pan out with the courts. So the best analogy we always give is that the law is the skeleton, the bones. The Court of Cassation decisions, which is our version of the Supreme Court, let's say, is the one that comes in and puts the meat on the bone. So anything that is not clear within the laws themselves or is disputable, the court cases come in and they justify and clarify the position. Now, because the law is still new, we still haven't gotten answers on all the questions that have been raised. So some of the answers will be that we still have yet to, we have yet to see what the Court of Cassation will come back in terms of their decisions and what is the jurisprudence behind those decisions themselves. So quite a bit of significant changes, and I can delve into them little by little.
Thank you, Mr. Ahmad. Having said that, Mr. Ahmad, could you please tell us what are some of the key changes that employers and employees need to be aware of?
So I think, like I said at the beginning, the most important one is this limited versus unlimited term contract. One of the other ones is, which was crucial in this law, is the definition of the word wage. So in the old law, they didn't clarify specifically what wage meant. Now in the new law, it talks about remuneration, which is your basic salary, your allowances, commissions, so on and so forth. The new law actually uses the word basic salary, basic wage, and remuneration. So this definition made it far more simple and determinable for the employer and the employee to be able to find out exactly what their rights are and how to move forward. Some of the other changes related to, for example, the biggest one, I think, relates to the concept of arbitrary dismissal compensation. So under the old law, we used to always say that if the company terminates you for reasons outside of the law, it's considered arbitrary and you will receive compensation up to 3 months. The new law doesn't have that concept whatsoever. So if they decide to terminate you due to restructuring, let's say, which is a viable reason for the employee, for the company, but it's not necessarily the fault of the employee, let's say, then that becomes a problem because they only owe you end of service benefits or gratuity, your notice period, and any accrued and unutilized annual leave. Back in the day, there used to be an extra compensation to say that because you were not terminated what was deemed lawful, then you would get that extra compensation. The new law does not have that concept whatsoever. So from an employee point of view, it's actually at their misfortune. From an employer point of view, it's actually a benefit to them. So it depends on who you're representing at this point in time, or who's asking the question. There is one situation that they allow for this compensation, but it's only if the employee files a serious complaint with the ministry and then the company decides to terminate him. That's the one exception to that rule. And it says shall be compensated. We still don't know what that compensation will be. Maybe another one, just a quick one, is relating to work categories. So the old law used to talk about the full-time employee. We now have a definition for full-time, part-time, full-time, part-time. You have flexible time, and you have ones that are to be determined by the implementing regulations. So there's a lot more flexibility in terms of the law, even in calculation of time, visas, so on and so forth. So it did give the companies more flexibility in terms of the employee doesn't have to be fully employed by them, which means they accrue more benefits. So, and for people who are working on part-time, it grants them the right to be able to work part-time rather than full-time and be obliged with the minimum requirements for the law. So these are just some of the ones I would think are the most crucial.
Thank you, Mr. Ahmad. That was very informative. Also, Mr. Ahmad, could you please throw some light on what are some of the ways that the new law will impact the employers?
From the employer's perspective, I think it goes both ways, the idea of it being limited. So you go and you invest all this time into an individual, training, the technical know-how to perform their jobs, so on and so forth, but they're on a limited term contract. Now, when the law was first released, it mentioned that there was a maximum of 3 years limited term contracts. The ministry was not allowing us to register anybody beyond 2 years. So this is sometimes the point of contention we have, is that the law would say one thing, but in practicality, the implementation of it is slightly different sometimes. Now, they've come out, I think a couple of months ago, and said that it's no longer limited to a specific time. You just have to limit the period. So you can say 5 years, you can say 1 year. So from an employer's perspective, I think in addition to the fact that it's now limited is the expenses. So if you're a company that has 100 employees and you have to implement the new law, you have to make those changes to every single employee. So everybody has to be on a limited term contract as per the templates that have been provided by, whether it's the free zones or the Ministry of Human Resources and Amortization. So from a practical point of view, I think all HR departments have been working overtime just to be able to implement the new limited term contracts. The other burdensome part was just these questions on what happens if we, what is considered a serious complaint to the ministry, for example. We still don't know what that is. So there were a few items that were difficult, and the authorities realized that this is going to take a little longer than they anticipated. So they gave 1 year. They've actually extended it till I believe it's till the end of the year for everybody to regularize all of their contracts. Some of the free zones didn't issue their template formats of these employment contracts till I think about 8 months after the law came out. So we had clients coming to us saying, okay, so we need to put new limited term contracts, but what's the template? And the authorities hadn't released them. So it was just going through the motions of implementation of the new law that was a little difficult on the companies in certain problems.
All right. Thank you for sharing the valuable information, Mr. Ahmad. Also, this is just the extension of my previous question. So can you please share some insights on what are some of the steps that employers can take to comply with the new law?
In terms of the employers, I mean, the ministry, for example, MOHRE has made it a fairly simple standard process for them to be able to re-register the employees under a limited term contract. So they provided them with the templates, they provided them with the timelines, they provided them with assistance. So they've made it a little easier in terms of the practicality of implementing it. There are obviously certain aspects like, what if I want to add the commission? So I have a real estate broker that earns a fixed salary of 1,000 dirhams, but he's paid a commission. Some of the times when we've gone to the ministry, they've rejected the wording that was used for the commission. So we're finding it a little difficult sometimes to implement what the companies or the employers need within the contract itself. So what ends up happening is, the double contract. You have the standard Ministry of Human Resources contract, and you have a second layer of the internal contract. Both of them will apply. It depends on which is more beneficial to the employee, it depends on when they were signed, a few other aspects as well. So the companies will have to implement the regulations and will have to implement the new contracts. There's no two ways about it. So I think it's just a matter of managing how they're going to be registering these people, because it's a cash flow problem as well. If you have 1,000 employees and you have to pay, I can't remember what the amount was, but if it was, let's say 500 dirhams, it's going to be a costly endeavor on the employer to be able to do it. So our suggestion was, whenever their visas were due to be renewed, renew the visa and the employment contract at the same time because you're paying irrespective. So it's just a matter of planning out how they're going to be implementing the new contracts. I think that would have been the struggle for most of the companies, most employers.
Sure, Mr. Ahmad. Thanks for sharing your valuable insights.
Yeah.
Also, Mr. Ahmad, this was the employees' point, right? So now my question is, how is this new law going to impact the employees?
I think, again, the scare is always from the employee's point of view. So whenever a client of ours is an employee rather than an employer, they're scared that, you know, the company decides today that we no longer need you here and they can terminate them. Now, the employee will get the notice period irrespective of it, but that arbitrary compensation given based on the old law will give them that extra buffer for them to survive for, let's say, the next couple of months after, so that they can find a job. So from an employer's perspective, that buffer or that cushion is no longer there. So that's the main concern that most people have. Otherwise, I mean, that's generally the one that we're asked mostly about. The other one, which we've seen a lot of employers implement, which is illegal, is that in the contracts they're putting that should you leave me within the first year, you will have to pay me back all of my, you know, expenses on training, on visa, on employment, recruitment, so on and so forth. The law is very clear. The employee will never have to compensate the current employer for him moving to another company. The exception to that is the new employer, depending on the situation, might have to compensate the old employer for cost of hiring, so on and so forth. And the details of what those costs are will depend, again, on the court decisions. So as we move along in the next couple of months, maybe a year, court decisions will come out saying that, you know, recruitment is considered part of the compensation, but relocation is not. So at the moment, we don't have an exact defined statement saying that the compensation shall be X. So from an employee's point of view, we're always telling them, if you have that clause within your contract, first of all, you need to reject it. Even if you don't reject it and it's in the contract, you still have the power of the law protecting you. So people employees should be cognizant of the fact that this is not legal to be in place. And from an employer's point of view, they should know that they shouldn't be putting this as well. So this is something that we've been asked about. Non-competes, so non-competing provisions within the law. This has become a hot topic. There always was provision for it, but the new law specifically mentioned what 3 pillars are required for a non-compete to apply. Now, again, whether the courts will apply the non-compete clauses or not, this remains to be seen, because it is quite burdensome on the employer to actually implement and to implement those non-compete provisions. So from an employee perspective, the law is always supposed to be coming in to protect the employees. I don't think the new law is actually geared towards the employees. I think it's more geared towards the employers as it currently stands. Of course, this might change with the court decisions. So we have yet to see how it's going to be implemented.
Sure, Mr. Ahmad. Thank you for the elaborated answer. So while we continue our discussion, dear participants, I have a small announcement to make here. So if you have any questions regarding the discussion that we are currently having, please feel free to put them in the Q&A option of the Zoom control panel. We will be taking them up shortly. All right. So, Mr. Ahmad, speaking of the law, the illegal and legal practices and the law that is in place to protect the employees, this actually leads to my next question, which is, what are some of the things that employees can do to protect their rights under the new law?
I mean, look, the way the law is drafted and employment law in general is it's the bare minimum. even if you sign a contract which says you are owed less than what the law says, the law will supersede such provision. An example of that would be, for example, if I signed a contract with an employer saying that I agree to receiving 15 days annual leave per year, the law will automatically apply 30 days. So I cannot contract to something that is below the law. The more informed you are, the better position you're in. So the reason why the ministry went ahead and standardized the employment contracts, I mean, this is a while ago, this isn't something new, but they've become far more proficient at it, is the law, the template agreement cannot be amended. So whatever is written in the first provisions of that contract, those are the guaranteed rights of every single employee. Now, what we can add are the further terms. So stuff like commission, stuff like, for example, if they're allowed to take time off for sabbaticals or for completing their studies. So anything beyond what the law grants can be applied, but you cannot go below. So from an employee's perspective, I think the government and the authorities and the what's it called, legislators went above and beyond to actually make sure that the employees are protected as much as possible in terms of what the bare minimum is. So if you see a standard contract, know that this is what the government has issued. It has enough protection for you, but you also should understand your rights. So if you're not comfortable with a specific point, you have multiple avenues. There are a lot of articles available online talking about certain provisions. Reach out to a lawyer because they will tell you things that are beyond what is written in the law and what a practical approach would be. Calling the ministry has been very polarizing. Sometimes we've seen good results and good explanations from them. Other times we've seen that it wasn't on par. And the reason being, they are not lawyers. They're looking at the law from a practical point of view, but not looking at it from a legal point of view. So my advice to employees is read up on articles. If you're not comfortable with a specific provision, ask. You have a right to ask about that specific provision or the contract as a whole. Especially when it comes to these, we've seen them a lot of times where they're implementing the expenses of the recruitment, of the visa and stuff like that on the employees. This to me is probably the number one inquiry we've been receiving recently, because employers have read it in a way that, oh yeah, I can charge the employee back for all my expenses, whereas the law is very specific. The employee will not owe the employer anything unless they've taken, a loan, or there are some deductions for fines, so on and so forth. So rest assured, as employees, whatever is in that standard contract issued by the government, that is your bare minimum rights. And if you read it, it's fairly simple. There is no hidden agenda in those. So questions, ask lawyers or read the articles, I would think.
Sure, Mr. Ahmad. So I think we as an employee, we just have to be aware that there is provision all around to protect the employees over there.
Yes.
Thank you so much for sharing that. Also, Mr. Ahmad, do you think the employers might be facing challenges in complying with the new law? If yes, could you please explain what are some of the challenges?
I think from an employer perspective, you're asking about the employer, right? Not the employee.
It's
Yeah.
employer.
So from
yes.
So from employer's point of view, it's not much has changed other than the fact that you still have to move them to limited term contracts instead of unlimited. A lot of it is pretty much the same. It's just a variation on a few items that make a bit of a difference for them. But yeah, from an employer's perspective, you need to make sure, because till today we see HR departments within companies giving out advice that is based on the old law rather than the new one. So they're telling them, if you resign, you will have to pay me compensation as an employee. So even after the law has been around for a year, and there have been countless webinars, there have been countless articles, newspaper clippings, so on and so forth, talking about the implementation of the new law, the HR departments or the people who are handling employees as such are not cognizant of the changes. So maybe they haven't read it, but I fail to understand, I fail to believe that they don't know that there has been a new law implemented. So from the employer's perspective, they just have to make sure that, whoever is handling these particular questions, particular provisions, employees in general, they have to be adhering to the new law. I'm still surprised that till today we see these, HR departments coming to the employee and telling them that, you have to pay me back for your visa expenses. That's not what the law said. So they have to make sure that they actually read the law. It's a lot easier and a lot shorter than it was. It used to be, I think, 143 provisions. It's now down to 70 or so. So it's literally half the amount. So from an employer's perspective, just make sure you understand what the law is. Again, reach out to your local law firms or whoever the law firm you're dealing with and ask them all the questions you need to implement. So we have a lot of our clients that reach out to us and said, can you make sure that you change our internal employment policies and contracts to match the new law? And we went through the exercise of, amending and updating their contracts so that they're in compliance.
All right, that was very helpful, Mr. Ahmad. So again, once again, it's all about reading it up and seeking the right support and the communication. So thank you so much for bringing it up here. So my next question is, what are some of the potential consequences for employers and employees who do not comply with the new law?
The simple answer is fines. They will be fined. In terms of, so implementing the new labor law in terms of the contract is completely on the employer. They are the ones that have to implement it. The employee can request time again for them to do it. But if the employer doesn't go to the ministry and say, this employee, I need to update his information and update his contract, then they're falling short of compliance with the law. So if we're talking about the employers, I would urge them to make sure that they're following through with the minimum requirements from the law. From an employee perspective, if you're still on the old unlimited term contract and it hasn't been updated, you should be speaking to the company to say, listen, you need to be providing me with this information. So that, with this new documentation, so that we both make sure we're in compliance with it. Now, in terms of implementation and consequences of, let's say, them signing a contract which says you're owed, you can take 15 days off instead of 30, the law will default to what the law says. You cannot opt out. So you have that protection in terms of the employees. I think those are pretty much the consequences. I mean, it really depends on the relationship. When a relationship ends, one of the parties is going to be grieved, and they're not going to be happy with that decision. So going to the courts is probably going to happen at certain points in time, and the differences will be resolved at the discretion of the court. So we always tell the clients, if we're talking to the employers, the employee will be paid something. It's just a matter of how much. Do you owe them a notice period? How many months of notice period? So on and so forth. Gratuity, you will have to pay it irrespective. Under probation, out of probation. So it's a matter of how much you have to pay. Because we get a lot of clients who tell us, I don't want to pay them anything. Well, the law will grant them something. It's just a matter of how much of it is going to be paid out.
All right. So, yeah. Mr. Ahmad, looks like it is all given. So there is no chance to avoid it or do something about it. Yeah. So thank you so much for sharing these valuable insights. Also, dear participants, please start putting across your questions. I just have one last question from my end, and we'll be heading towards your questions. So, Mr. Ahmad, to conclude with, what is your opinion about how this new employment law changes positively impact the employees and employers? So basically, what are the positive impact of this?
I think with the certain points within the law itself, it's clarified a lot of the questions that people had on, how do I calculate end of service? Does it include commission or does it not include bonus? So certain things within the law have actually been clarified, and I think it's because of the fact that a lot of these questions have been raised by the courts. So the courts had to step in and actually clarify and justify the reasoning behind it. So I think in terms of clarity, the law has given a lot more clarification to certain points. But at the same time, these are laws made by legislators. So they are fallible, and there are certain things that we think we wish were clearer than they came out to be. I think with given time, we will see that the courts will start to, like I said, put the meat on the bones to clarify these items. I don't know what the positive versus the negative is of the law. The law is the law. We get this question a lot saying that, but this is not fair. Our response is always, whether it's fair or not doesn't really matter. The law is written in a specific way, and you're in a jurisdiction which says that if you break the law, it's very black and white. If you break the law, then this is what happens. If you perform within the law, then this is what happens. So our advice is always, it's not about whether it's fair or not, unfortunately. I got into this to serve justice, and I'm still seeking justice till now because it's not fair or logical half the time. But the law is written and we have to adhere to it. This is the country we have opted to move and live in. So we have to respect the fact that these are the laws and this is how they're made.
I think brilliantly said, Mr. Ahmed. Thank you so much for sharing your valuable insights on this. And it was truly a knowledgeable session. So I think we are, with this, we are done with the first part of this session. We will now be moving to our audience questions. So I can see there are already a few questions lined up for us in video here. So I'll just take them up one by one. So one of our attendees would like to know when a female employee is eligible for maternity leave.
So maternity leave starts after 6 months. So more often than not, the clients, the employers implement a probation of 6 months. So it's after the probation and after 6 months, usually when you can request maternity leave. A lot of employers, part of their recruitment process, are asking, are you pregnant or not? Because they need to understand, if I'm hiring you right now and within a month or two, I need to put you on maternity leave, it becomes difficult for the employers because they've spent all that money trying to hire somebody that is going to be away for quite some time. So the law is strict on this, and it said after 6 months, after 6 months, yeah.
All right. Yeah. Thanks for answering that, Mr. Ahmed. I hope this answers the question. And one of our attendees, the next question is, hi, thank you for arranging this webinar. Please let me know if we can get the recording of this. Yes, for sure. So currently we are recording this session. So once we are done with this session, we will be sharing it with all of you. So do not worry about it. All right. So Mr. Ahmed, I'll take up the next question. It is about the severance. So the question is, how is severance calculated on a commission-only salary?
So the law is very specific. It talks about basic wage. For you to calculate severance or end of service benefits or gratuity, it's only on basic wage, unfortunately. The old law used to say that if you've received commission for 3 months in a row, and it's a specific amount, that becomes part of the calculation for severance. The new law is very specific. It's only based on basic wage. So if you earn a basic wage of 1,000 dirhams, but you're earning commission of 100,000, it's calculated on the 1,000 dirhams.
All right. So thank you, Mr. Ahmed. I hope that answers the question. And our next question is about carry forward of the annual leaves. So the question is, how many days of annual leave an employee can carry forward to the next year?
So this depends on company policy. So the law says that you have a right to encash them at the end of the year or transfer them over to the year after. There is a cap of maximum of 2 years. So you cannot roll over more than 2 years, but it's normally down to the company policy. So if the company issues an email, a company-wide email saying that you are only permitted to roll over 5 days per year, that means the company has to grant you the remaining 25 within that year. So it really depends on the company policy. More often than not, they're saying 5 to 10 days max, not more than that.
All right. Thanks for clarifying that, Mr. Ahmad. And the next one is from one of our attendees again. Can you please tell us what's the template of the limited period new agreement as per the ministry's template?
I'm not sure I understand. What is the, what was that again? Sorry. If you can...
Template of the limited period new agreement as per the ministry's template.
Okay, so the templates are, I don't know if they're available online or not, but from these, what are they called? The centers, Tasheel or Tadbir, I don't remember which ones. They will have a template. It depends on whether you're in a free zone or within mainland. Each one of them have their own templates, but they've all followed the same process. They will all have the minimum requirements. They will all have the same structure, let's say. In terms of period of limited term contract, it depends on the company. For example, we're seeing a lot of 3 years and 5 years, some 1 year. So it really, again, depends on the agreement between the company and the employee themselves.
All right, thanks for answering that, Mr. Ahmad. Since we are already talking about template, I have another question from one of our attendees. It's about new employment contract template. So the question is this template applicable to companies under DDA free zone?
Yes, so DDA would have their own version of it. DDA, which is the Dubai Development Authority, is a mixture of both a free zone and a mainland. So it really depends on where you fall exactly, but both of them will have their templates already available. So DDA was one of the ones that took a little longer, so it should be available now, and they will have templates for both of them, whether the free zone or the mainland DDA license.
All right, so I hope that answers the question. Mr. Ahmad, our next question is about the new tax law inside UAE. So the question is, does this new tax law inside UAE cover the vendor's income who provide the online services for customers inside UAE?
So, I mean, this is not my specialty, but the basic answer is, and this is what I understood from tax accountants and tax lawyers, is that any income generated within the UAE or for UAE related entities, registered entities, will be taxable. If you are simply an online portal providing services to companies between India and the USA or China and Jordan, for example, you will be taxed at 0%. So you still have tax, but it's taxed at 0%. And there's the definition of qualified income, unqualified income, so on and so forth. But this is not my specialty. All I know is if it's conducted within the UAE to UAE companies or from UAE companies, it will be subject to corporate tax.
Sure.
But not income. We still don't have income tax. If this is about income, it won't count for income tax, no.
Sure, Mr. Ahmad. Thanks for the clarification. The next question is, actually, it's a very good question. So the question is, when employee leaves within a year, they don't tell us which company they are joining. So in this situation, how do we ask the future employer to reimburse the cost?
So normally, I'm trying to remember, the reimbursement cost is only applicable if the employee resigns within the probation period, and it's applicable for 3 months. So if they don't tell you, I mean, the practical approach is, you know, everything is on LinkedIn. Just log on to LinkedIn, you can find out whether they've joined a new company or not, and then you can follow through with it. But yeah, it's only applicable if it's a resignation within probation period. After that, it's not applicable. So they will not be able to claim that amount.
All right, I hope that helps. So the next question is, as per employment laws for free zone and mainland, what is the leave salary an employee is entitled to? Is it based on basic salary or a full month salary?
So under the law, you are entitled to full pay as part of your annual leave. Because you're entitled to 30 days within that year, you will be deemed employed, although you're not doing any work, but you are still owed the full amount of salary and those days off for that period of time. It's not on basic salary.
All right.
Now, if you're going to be compensated, for the annual leave because you have not taken it, if I remember right, it does talk about being paid for your basic salary. So let's say the end of the year rolls up and you've got 10 days and the company will only allow you to roll over 5 days and you need to get paid for 5 days and remaining. That calculation is paid on basic salary, not on full. That's the distinction between both.
All right. So in the similar lines, Mr. Ahmad, we have our next question. It's clearly about leave encashment again. So the question is, on leave encashment, the law says, is it based on basic salary or salary with all the fixed allowances?
Yeah, it will be on basic wage. For if you're going to be paid, compensated in lieu of annual leave that has not been utilized, it will be on basic wage.
All right. So the next question is, thank you for this session. And one of our attendees would like to know if the annual air ticket from and to of the home country is part of the new labor law.
So there are 2 different types of tickets or flight allowances. You have ones which are contractually agreed upon between the parties, which says, let's say, every year in September, I get 1 return ticket. So you are owed that return ticket if September comes along and you are still employed and then terminated afterwards, then you are entitled to the contractually agreed upon ticket. Now, the other form of the ticket is what is deemed repatriation. So repatriation would say that, you know, I'm leaving the country, I've been terminated or I've resigned, and I'm not looking to stay in the country. That ticket is by law, and the employer will have to pay it, and it's a one-way ticket to the employee if the employee doesn't transfer his visa or doesn't stay within the country. That's the only time they have to pay it. So scenario 1 is I have an employee who's been terminated or has resigned and is looking to move back to USA. And he is actually going back to USA. You as the last employer will have to pay for that ticket. You can purchase the ticket and tell him, tell me which day, I will buy it for you, and you can purchase it and he can go back. The other scenario is if the employee says, you know what, I'm actually staying in the country, but you owe me this ticket. That is not going to happen because the law says that the last employer, where the employee has served and where the employee is moving back to his country will owe it. So let's say I move from company A to company B, then company B to company C. Then I decide I want to move back to the US. Company C will have to pay me for that repatriation ticket, not B or A. So contractually agreed upon ticket and the ticket as per the law. 2 different things. Hopefully that answers the question.
Sure, Mr. Ahmad. Thank you for that. And our next question is about leave accrual. So the question is, on leave accrual, when employee accumulates a large number of leave balance, there are basically 2 questions in this. First one is, can the company pay it out and reduce the leave balance? And the second question is, can the company write off the leave balance beyond a number? For example, let's say anything over 100 days will be written off.
Yeah. So this is where the law clarified the fact that any annual leave that is owed beyond 2 years will drop, unfortunately. So if you have leave from 2018, be it 1 day or 50 days, you will no longer receive compensation for those, and you have no right to claim them. So we did this exercise with one of our clients where they had one employee who's been with them for I think it was 18 years or something, and he had over 180 days of annual leave. Now, as per the law, they could have told him, there's nothing we can do. We're going to give you maybe a fraction of those, and the rest will have to drop off. But they chose to pay him out for those days because he did serve that time, and they wanted to do that the ethical way, not necessarily what the law forces them to do, but they thought, you know what, this is a good employee and we want to reward him for the time he spent with us. They paid him for the 180 plus days. But as per law, it's capped at 2 years. So if you have days from 2019, they're gone. Unless the company decides to, you know what, we actually do want to pay you.
All right. So thanks for sharing that, Mr. Ahmad. Next question, it's a very interesting question actually. So the question is, while an employee is asked to work during the UAE public holiday, is it mandatory for the employer to pay that day's wage, or is it okay for the employer to just adjust it with the compensatory off and do not pay the wage for that public holiday which he has worked for?
No, so there are exceptions to when you pay overtime or days in lieu of public holidays. So public holidays, I think, is wage plus 50% extra. So let's say your daily rate is 1,000 dirhams, you get 1,000 plus another 500. So they have to compensate you by law. It's not a question of whether they feel like it or not. The law says that you have worked during the public holiday. And again, it depends on the industry. So for example, if you're in the hospitality or restaurant industry, you're most likely going to be working during public holidays. The employee has to be compensating you for that time.
All right. So I hope that's clear. So Mr. Ahmad, that next question is about the labor card numbers. So the question is there any change of character count in the labor card numbers?
Labor card, I think if I remember right, the labor card changes with the entity the employee is registered under. So I don't know, to be honest. This is from a practical point of view. I'm not sure about what happens on the labor cards as such. But that's probably, I mean, if I have to think of it from a practical point of view or logical point of view, if the company's number should be part of those digits, and the employee number within it. If the entity changes, then those initial numbers change and his number changes. But if they're changing the name of the company, for example, or ownership, that number shouldn't change. No. So I don't know how to answer that question.
No problem, Mr. Ahmad. So I hope this also helps. So thank you so much. Also, dear participants, we can see there are a lot of questions lined up for us. We are really happy to see such sort of engagement. We really appreciate this. However, due to interest of time, we may not be able to take up all your questions, but please don't be disappointed. We are trying our best to take up most of your questions. And if anything is missed out due to interest of time, do not worry about it. We will definitely share the session recording with all of you. You can watch it later at your convenience and get answers to all your questions. In the meantime, I'll just take a few more questions, Mr. Ahmad. So the next question is, again, if the employee still works and receives his monthly salary even after his employee contract has expired, that is if the contract is automatically renewed, whether is that done? And in connection with the previous one, does the employee need to render notice period while he resigns, or since his initial contract is expired and employment contract renewal has been delayed, there's no need to render any notice period. How does this work?
So the short answer is, if the employment contract has not been physically renewed, but the parties continue to work together, it's an implied renewal, which means the same terms and conditions will renew for another year. Now, I don't know from a practical point of view if the ministry will have a system saying that, you know, we have an employee within your company that has no updated or renewed fixed term contract. I'm not sure about that from a practical point of view. But from a legal point of view, if you continue to work with the company and no party has terminated as such, it renews automatically for the same period of time based on the same terms as the original one. The second part was talking about the notice period. So notice period is only needs to be served if there was a termination or a resignation. So if the employees, again, if the employee and the employer continue to work with each other, then the contract renews and there's no need for a notice period. What we always recommend is that the employee send an email, or the employer send an email saying that we wish to continue. The agreement is being drafted and being prepared, and we will send it to you when it's ready for, for signature. But yeah, you will have to still sign, but it automatically renews if no party has specifically in writing said that it's terminated.
Sure. Thanks for highlighting that, Mr. Ahmad. Dear participants, I'll just take up two last questions for today before we conclude this session. So, Mr. Ahmad, our next question is about gratuity. So, my employer was settling the gratuity on yearly basis on anniversary of contract. Now, with the new law, they have stopped it. So is there any option now that I can get the differential amount for past years considering the increased salary?
So we've been asked this question before, and I learned this from my litigation department, is that you can agree with the employee to actually settle their end of service gratuity per year upfront, or monthly even. We've seen it on a monthly basis. Now, unfortunately, if the salary increased, let's say this year, you cannot ask for the differential of the years before, because you've contractually agreed to be receiving that gratuity calculation for that year. So up until the point when you renewed your contract and you increased your salary, but you were paid on a monthly or yearly basis, you will not be able to reclaim the difference, unfortunately, no. But for the next year, it's based on this new salary, or the year you're in within right now.
All right. Thanks, Mr. Ahmad. I hope that helps. Also, Mr. Ahmad, we were talking about the notice period, right? So there's one question related to that. So the question is, can companies set more than 30 days of notice period for an employee? Like, for example, 60 days or 90 days. And in that case, how is the notice pay calculated on both sides? That is the employer and employee. In specific, is it based on total salary or only on the basic salary?
Okay, so the law specifies that you can have a notice period between 30 days and 90 days. That's the regulatory requirement, 30 or 90. And you are paid for that period of time your full salary, not basic salary, full salary for the notice period. Now, the one thing I will say about notice period is, if the employer says to the employee, I'm putting you on garden leave, you don't need to come to the office, he has to pay him full salary for the notice period. If the employee comes to the employer and says, because you've terminated me or I've resigned, I don't want to work that notice period, the employee is not entitled to the salary at all, because he's told the employer that I don't want to work anymore. So basically, the employer, if they decide we want you to work your notice period, or they decide we don't need you to be at the office, you can stay at home, garden leave, they will have to pay it. If the employer requests that he does not want to work that period, he will have to compensate. And he will not receive his his salary for that notice period.
All right.
I actually saw one question, if you don't mind, Ms. Rashmi, about the unemployment insurance scheme. They were asked, somebody was asking whether the employee or the employer is responsible for the registration. So in this particular case, the employee himself is responsible for registering with the unemployment insurance scheme. You can opt to do it for 1 year, you can opt to do it for 2 years, and you can opt to do it on a monthly installment basis or yearly. They've made it so easy for everybody to be able to pay it. But the obligation is on the employee, and it takes less than 60 seconds to do it. You just enter your Emirates ID number, it populates the whole document, and you click on pay. So it's a very, very simple process, very simple.
Sure. Actually, Mr. Ahmad, you read my mind. I was about to take that question. Thanks for answering that.
No problem.
So on this note, dear participants, we are about to conclude our session. But before that, if there are any questions pending, do not worry about it. You can send your questions on the mail ID that you can see on the screen. We will definitely get back to you with the responses for that. So once again, thank you, Mr. Ahmad, for this session. You have certainly given us a lot of great insights on 2023 UAE employment law changes and its implications for employees and employers. Also, thank you
very much for having me. Yeah.
Glad to hear that. So thank you, Mr. Rashid, as well for being our partner for this webinar. And of course, thanks to all the attendees as well who has joined us today and have made this session very successful. If you have any more questions, as I already mentioned, please feel free to write back to us on the mail ID that is shown on the screen, that is yasir.arafat@greytHR.com, and we will definitely get back to you with the responses. So on this note, I'm going to end the session now. We will see you all again in the next session with another interesting topic of discussion. Till then, have a great time. Stay safe. Thank you.
Thank you, everyone. Bye-bye.
Thank you, everyone.